Well, good morning and welcome to hsa-bc and TRAC's webinar, Evictions and Rent Support Changes for September 2020, although some of them have come into effect now. I'm Sarah, so that's who you're hearing when you're on the line with me. I'm your host for today, and I've worked in the frontline nonprofit sector for over 15 years, including in Vancouver's downtown east side at Carnegie Community Centre. I develop and host webinars for hsa-bc, as well as instruct mental health first aid and produce podcasts for mental health organizations here in Vancouver. So when you're using the question section, that's me who you'll be chatting to. And I'll do my best to share your questions and comments with Michelle as they come up. All right, so I'm going to run a little poll here, and this is just to give us a sense of who you are. And what you're bringing to the table today. Some of you have already typed that into the question section, which is fantastic. But just tell me a little bit about yourself. Are you a frontline worker? Are you a support staff member? Maybe you're on the board or you're in a leadership position in your organization. You're a manager or a supervisor, or you can choose other and type into the question section so that we know. There's lots of tenant support workers on the line today. This information is really crucial for you, I know. So let's take a look here. 43% frontline workers, 20% support staff. Great to see a few board members and EDs on the line, and some managers and supervisors. And of course, as I mentioned, lots of housing support coordinators, coordinators of housing, tenant support workers, and lots of others. So welcome to everybody. This is my favorite part, introducing your instructor to you. This is Michelle Bida, and Michelle attended UBC Law from 2012 to 2015, where she was active in the Law Students Legal Advice Program, a student-run nonprofit providing free legal advice and representation to low-income clients. After graduating, she began as the legal advocate with the North Shore Community Resources in North Vancouver, as well as at Mosaic, before moving to an advocacy position with First United in Vancouver's downtown east side. And since January, she has been responsible for TRAC's direct representation program, offering advice and representation to tenants facing systemic residential tenancy issues. So Michelle really is exactly the right person to take us through the complex and new developments that we're seeing in the rental world today. Welcome, Michelle. It's great to have you with us.
Hi, Sarah. Thanks for inviting me. Glad to be here. Okay, so I'm here today to talk about the recent changes to the Residential Tenancy Act that the government enacted as a response to the COVID-19 pandemic. I'm with TRAC, as Sarah mentioned. We're the Tenant Resource and Advisory Center. We're based in Vancouver, but our scope is provincial, and we work with tenants throughout BC, providing information, education, legal support, and research on residential tenancy matters. So this is just a bit of an overview of what TRAC does. We operate a tenant info line, which runs 1 to 5 during weekdays, except Wednesday we run it in the evening from 5:30 to 8:30. There's a local and a toll-free province-wide phone number. That's a really useful resource for people doing advocacy or frontline work as well. You can always call us if you have questions, sort of on behalf of your clients. We do direct advocacy. We operate these legal workshops and webinars like the one we're doing today to provide kind of legal information to people involved in residential tenancy. We provide some plain language publications. We operate a website where we've kind of collected all of these resources. We have a bit of a social media profile. We now have a Facebook page too, where people can ask us questions or send us messages. We have an online course, Renting It Right, and we do as much systemic advocacy as we can. So bringing the needs of renters to the provincial government and various task forces that they set up on residential tenancy law So just again, a brief overview of what residential tenancy law is. It outlines tenant and landlord rights and responsibilities. It's specific to British Columbia. So BC has a Residential Tenancy Act and a Manufactured Home Park Act that is specific to renters in BC. Different jurisdictions, different provinces and states have different tenancy law. In BC, landlords and tenants cannot contract out of the Residential Tenancy Act. If they fall under the scope of the act, then they have to follow the terms and conditions that are set out in the act. And a tenancy agreement can't contain unconscionable terms or terms that are would be considered oppressive or grossly unfair to a kind of reasonable observer. In BC, we have a residential tenancy branch that operates dispute resolution, which is a kind of court. It's almost always done by teleconference. It takes about an hour. An arbitrator will listen to both parties and review whatever evidence has been submitted or provided, and then make a legally binding decision. There's a $100 fee to make an application for dispute resolution, but that fee can be waived for people who are low income. And of course, even though it is a teleconference hearing, evidence is very important, whether it's documentary evidence that was provided in advance or the testimony of the parties or the witnesses that they bring in. So just to clarify that not all housing in BC is covered by the Residential Tenancy Act, I guess key for folks that you might be working with is that emergency shelters or transitional shelters are not covered under the Tenancy Act. Some other types of housing that aren't covered are co-op housing. So if someone is a member of a co-op, they're governed by the co-op's own regulations. Student housing provided by a school, so dormitories. Vacation or travel accommodation, hotels, and short stay hotels aren't covered. It's single room occupancy and other hotels or motels like that that are renting rooms on a longer term or monthly basis usually are covered by the act. If people are in non-residential tenancy housing, they can usually resolve disputes through the Civil Resolution Tribunal, but that doesn't provide the kind of robust protections especially for security of tenure that the RTA does.
And Michelle, just a clarification there. If someone is in a hotel but they're paying a monthly rent, would they fall under the RTB?
Yeah, they likely would. There's kind of a series of considerations that an arbitrator would look at if the question of jurisdiction is brought in, usually by a landlord who wants to avoid being covered under the Act. So most, like in Vancouver anyway, most of the SROs, the hotels that house a lot of low-income people at welfare shelter rate will be covered under the Act. You know, if there's a monthly rent, if there's a damage deposit, if there's kind of an expectation that there's an ongoing tenancy, the likelihood is that it would be a Residential Tenancy Act tenancy.
That's helpful, thank you. Because I know that's a situation for a lot of people.
Yeah, and it can be unclear with some subsidized housing, a lot of nonprofit housing providers who are operating things like, recently we've seen some motels be taken over by the government to operate subsidized housing. BC Housing is providing housing. There seems to be a trend for the housing operators there to kind of try and say that they are in fact transitional housing, when really traditionally we would have considered them to be supportive housing, which is covered under the Act. Transitional housing, which is supposed to have a clear and pretty short end date, and in which people there's supposed to be a plan of some kind to actually move them from that transitional housing into permanent housing. Housing providers do sometimes try and get out from under the act by saying that they're transitional or therapeutic housing. There's a few other types of housing that are excluded. So I'm just going to go over a little bit the background of the provincial government plan that they put in place to deal with the pandemic. So at the end of March, the government made an announcement that they would be bringing in some changes to protect renters. And one of the things they said that we've been trying to hold them to is that nobody would lose their housing because of COVID-19. So effective March 30th, the government's ministerial order, this was number 89, was passed to amend the Residential Tenancy Act. And what that order did was implement a temporary ban on evictions of all kinds. So it wasn't just for non-payment of rent. Cause evictions and landlord use evictions were also temporarily stopped. It was still possible for landlords and tenancies for kind of what you might call gross misconduct, for endangering another tenant or the property or the landlord, or illegal activity that was going on in the unit. Tenancies were also able to be ended sort of for health and safety reasons. So, for instance, if the city had moved in and said that the suite is illegal and unsafe, then a landlord would still be able to evict that tenant and get an order of possession from the residential tenancy branch. Part of that was that the Supreme Court was also not going to be providing writs of possession for the duration of the state of emergency, except, again, in those cases where the landlord had obtained an order of possession through this sort of expedited process for very, very serious problems where tenancies needed to be ended. So at the same time, the residential tenancy branch issued a couple of sort of practice directives to do with COVID. One of them was about extending timelines. Now, timelines and deadlines at the RTB traditionally are very rigid and very difficult to get around. So if you're even a day or two late filing, or even if you filed on time but your client's fee waiver didn't get processed until a day or two later, very often the application would be dismissed unless there were extraordinary circumstances. The RTB kind of defined those by policy as being that the person was sort of in the hospital throughout the entire period and they were incapacitated even from having somebody else go and file on their behalf. So this practice directive was quite helpful because it directed arbitrators to take into account COVID circumstances. So if people were self-isolating or had to be in quarantine, or if they were immunocompromised and there were issues with getting out to serve a notice or mail a package, the arbitrators would consider those circumstances. The director also allowed email service of documents for the first time. This was an important step to help keep people safe. They also allowed people to serve certain documents on the branch that used to have to be filed in person at the branch. They set up a special email address so that people could file and serve amendments and things like that on the branch without having to go into a physical office. So then at the end of June, we saw the government issue Order M195, which rescinded that original emergency order. So, sorry. So that order set up the government to implement this kind of repayment plan idea that they came up with. So well, first of all, they lifted the ban on evictions for everything other than non-payment of rent or late payment of rent. So people were once again able to be evicted for landlord use or for cause. That emergency order set up a regulation that sort of set off unpaid rent that accrued between March 18th to the then undefined end of the state of emergency as affected rent. So people who were unable to or late paying that rent in that period were still protected from eviction. The types of evictions, and they were quite clear setting out that landlords couldn't evict for, they couldn't give a 10-day notice for late payment for that rent accrued in that period. They couldn't give 1 month notice for repeated late payment of rent. They also couldn't give a notice for material breach, where the material breach was the non-payment of rent in that period. They basically closed all of the loopholes that landlords might find to be able to sneak this non-payment in this period into some kind of notice. At the same time, they rescinded the practice directive on extending timelines and the director's order about email service. So it became impossible to serve by email after that date. They have said that they will reinstate email service. We were hoping to see that happen for September, but so far I haven't heard an update on email service. So for now, we've gone back to the old way where you'd have to serve in person or by registered mail or posting or the other ways that are allowed under the Act. Yeah, and as I said, evictions for other than unpaid affected rent were reinstated.
Michelle, so for example, eviction for endangering property, would that now be retroactive? So you couldn't do that during the moratorium, but now landlords can follow up on that?
Not for affected rent.
Okay.
So if the landlord is saying, oh, I'm in danger, my property's in danger, maybe because I got behind on my mortgage because this tenant didn't pay rent during that period, no, they still can't do that.
Okay.
That rent payment period is kind of, it's set off, like it's protected in a kind of a way, although a very limited way as it's going to transpire. So at the end of July, the government repealed that emergency order and issued a new amendment to the Tenancy Act regulation. And this piece of legislation outlined this repayment plan idea. So basically, any tenant who has unpaid affected rent at the end of this state of emergency will have to be given a repayment plan by the landlord. Landlords won't be able to charge any administration fees with respect to that affected rent. They can't charge late fees either. And again, affected rent can't ground evictions for non-payment or repeated late payment, for material breach, or for any kind of risk to property or a lawful right of the landlord. However, default of a prior repayment agreement or one of these new repayment plan agreements could result in eviction. So what we'd seen starting in about April is that some landlords were already offering, or not offering, they were telling tenants that they had to sign a repayment agreement, and depending on the terms of those agreements, it may or may not have been possible for landlords to evict if those repayment plans weren't met. Under this new legislation, the government basically said, yes, if a tenant is in breach of a repayment agreement, whether it's this new one that's going to come up or whether it's one that's already existing, that can be grounds for an eviction. So one thing this legislation did, though, is it gave a tenant the power to cancel a prior agreement by themselves providing a new repayment plan to the landlord. So if the government's repayment plan terms are better, they're more favorable for the tenant can cancel the one that the landlord had previously given them by giving them one of these new repayment plans. So the other main thing that this piece of legislation did was to say that rent increases that were issued to go into effect April 1st would go into effect on December 1st instead. So you remember there was a rent freeze that was imposed such that new rent increases couldn't take effect during the emergency period. That's now been sort of ended, and the effective date for new rent increases is going to be December 1st. Sorry, it looks like part of that is cut off on the slide.
Oh, yeah.
Yeah, it should say at the bottom there, will instead go into effect December 1st, or after November 30th is the way they phrase it in the legislation. So then August 14th, the government issued a new amendment. So there was an order in council that was made, and this is regulation number 2 that replaced the one that was issued previously. So this is essentially was the cancellation of most COVID protective measures and the beginning of these repayment plans. So initially when they talked about it, they said none of this would take effect until September 1st, but ultimately what's happened is that they made it for August 18th. So although most people do pay rent on the 1st, anybody that had an odd rental payment period that started August 18th or thereafter, August 18th became the day that the affected rent period ends. So as of August 18th, you have to pay your rent in full or on time, or you can be liable to any of the sort of traditional eviction methods for non-payment of rent. So this order in council set the affected rent period from March 18th to August 17th. And they've said that a repayment plan can be issued anytime thereafter, beginning August 18th. So as of yesterday, a landlord who had outstanding rent owing could have drafted one of these repayment plans and served it on their tenant. The way the repayment plan terms are set up, the first repayment installment can't be until 30 days at least after issuing the repayment plan. The last payment must be made by July 10th, 2021. So that's not a long repayment period.
And sorry, Michelle. So does that mean tenants can put forward repayment plans as well? No?
They can, yes.
Yeah.
Yeah. Yeah, I'm not sure why they would want to, unless they had an existing repayment plan that was less forgiving.
Right.
As it stands, you can't be evicted for anything to do with affected rent, but you can be evicted for defaulting on a repayment plan. So yeah, as I said, any unpaid rent owing on or after August 18th has to be paid in full or on time. Tenants can again receive 10-day notices for non-payment. They can get a 1-month notice for repeated late payment, not for payment like affected rent payments, but say a tenant was late, in January and February of 2020, and then they're late again for September 1st, the landlord could issue them a 1-month notice for being late 3 times. And other 1 month notices related to rent could be issued. So material breach or Sarah, as you said, like threat to property or risk to property. That ban on evictions related to unpaid affected rent, though, does remain in effect. The ban on evictions for other reasons, as I said, have been lifted since June 24th. So we're certainly here at TRAC, we're certainly seeing lots of new 2 month and 4 month and cause evictions that have been issued in the last 6 weeks. So those the landlord use evictions are for either a landlord or their family, or a new purchaser or their family are going to be moving in or say they're going to be moving in, or for renovations or demolition that require vacant possession.
So I've got a flurry of questions here around the terms of the repayment plan, but it looks like you're
so
getting to it
we'll
right
go
now.
into that. Yeah, I just wanted to give kind of a general overview. So here it is here, and I've kind of mashed together all of the required terms and the modifications or the amendments that will be allowed under the Act. So there are sort of 4 main things that are required in a repayment plan, apart from that they have to be in writing. But they have to have the date the repayment period starts, the end date, which has to be July 10th, 2021. It's really what that means. It can't be any earlier than July 10th, 2021. It has to set out the total amount of rent and utilities that are overdue. It has to set out the date on which the installment is due. And it has to say the amount that must be paid in each installment. And so within all of those requirements, there's sometimes some flexibility, but starting back at the top there again, the date that the repayment period starts can't be less than 30 days after providing the plan to the tenant. So as I said, if a tenant's rent is normally due on the 20th for some reason, a landlord could issue a repayment plan to a tenant on August 19th, and then the first installment payment could be due on the next rental period on September 20th. So the repayment period has to be at least until July 10th, but it may be extended by amendment if a landlord wants to do that. The date must be on the date of the usual rental payment, so on the 1st for most people, but it can be amended to a later date. So again, I think this goes back to the minimum 30 days thing. So if rent is normally due on the 20th, a landlord can issue a repayment plan on the 19th and say, okay, your rent is due on the 20th, but I'll give you until the 1st to make your installment repayment. So the amount has to be equal installments, but it may be amended to allow smaller payments earlier. So a landlord could say, a tenant could say, well, listen, I'm not back at work full time. I don't have enough money to make these repayments, but I hope to be back in full employment in November. So a landlord can say, okay, the first couple months, you only pay $100 or $150, and then it will go up to December to $300 starting in December. Are there any questions about that?
Yes.
I don't think there's any more details. Okay.
So they're sort of around who decides what a reasonable repayment plan is, and standard amounts, as well as
So all it is you take that full amount that's owing, and you divide it by, what is it, 10, I guess. If you have, say you've got September 1st, or the 1st is your usual payment, so you've got September, October, November, December, January, February, March, April, May, June, July. So you've got 11 months. So ordinarily, let's make it easy. Say you owed $1,100 in unpaid rent. that would be $100 a month.
Okay.
Divided up equally. Now, if you had a very sympathetic landlord, they might say, well, I'm willing to give you 2 years so we can extend the repayment over 20 months. Then it would be, sorry, my arithmetic's not great. Say they made it 22 months, and then it would be $50 a month.
Mm-hmm. Now, does this legislation mean, like, can landlords refuse a payment plan?
No.
Okay.
I mean, they can't evict for non-payment of rent. Like, they have no way to sort of get a tenant to pay that rent unless they offer a repayment plan.
Okay.
A like valid repayment plan under the legislation.
That's helpful. And then the other thing, is there any way for them to work around so that they can demand all of the rent at once, or do they?
No.
Okay.
No. That's the only advantage of this legislation. I mean, over what we'd hope to see was some kind of rent forgiveness program or some kind of way that landlords could apply to a fund if their tenants, if they were low income and their tenants were low income and there was no way to get this rent back, that there would be some kind of program like that. No, what this program says is everybody has to pay back all the rent that they owe, but there's only one way a landlord can do it. The bare minimum they have to offer is this 11-month repayment period. No interest, no admin fees, no late payment fees.
Okay.
Does that make sense?
Yes. And then there's a question here around if you are evicted for other causes, does that unpaid rent have to be paid back in full at the eviction date?
Yeah, I mean, that's a really good question. How are they going to deal with that? There's no real answer to that. I would suspect that I mean that's the real question for that is for a landlord, how are they going to collect on this unpaid rent? I don't think that they would be able to get a monetary order for that full amount. I think the landlord and the tenant would both be considered to still be bound by the terms of a repayment agreement. So I think the tenant would still be responsible for making these installment payments.
Mm-hmm. Which kind
How
of
a
brings
landlord
me...
would be able to force them. I mean, I guess the same way a landlord can try and enforce any monetary order that they get from a tenant, they'd have to go and file in provincial court for enforcement and try and, I mean, many tenants are going to be, many of the tenants that we're working with that are low income are going to be judgment proof. Like they're not going to have the kind of income and assets that would enable a landlord to collect from them in any kind of reasonable way, like garnishing wages or garnishing a bank account or putting a lien on a property or anything like that.
Right. And then it kind of leads into this question around what if a tenant defaults on repayment agreement, but you may be getting to that.
That's, yes, eviction is there's our next slide. Eviction is possible for non-payment of installment. So if the tenant fails to make a repayment under the repayment plan, just like rent, if they make a late or a partial payment, an eviction notice can be issued for that. So essentially, repayment installments are exempted from the definition of affected rent. So it's kind of like you have this, say you have this pool of $2,000 of unpaid rent that accrued between March 18th and April or August 17th. They can't be evicted for non-payment or late payment of that until it falls due in an installment, at which point it kind of moves out of that affected rent pool and into a current rent due pool. So the legislation sets out, this new legislation And 7.1 says a landlord must not give a tenant notice and a tenancy under section 47 in respect of a reason that relates to affected rent being unpaid. And then in 2, it says for certainty the payments in subsection 1A, that's the repayment plan payments, do not include the payments in 1A is just above rent payments. They do not include an installment to be paid under a repayment plan. So affected rent, you can't issue a notice for, but as soon as that affected rent comes due in an installment payment, if it's not paid, then a eviction notice can be issued on.
I'm trying hard to wrap my brain around this, as I know probably many people are.
So you have this $2,000 that you owe that's accrued. A landlord can't issue a notice just based on that.
Right.
Because if there's this repayment plan. But if you can't make part of that repayment plan, then they can issue a notice on it.
Okay. So bottom line, a repayment plan is a good idea for a tenant.
Yeah, I mean, unless their landlord just isn't insisting on repayment otherwise. Like certainly it's much better. A landlord can't just say, okay, you owe me $2,000 and if I don't have it in 5 days, you're out.
Right.
But it's not as good as, hey, don't worry about it. We'll add, $25, or if you can repay me half of that, that would be great. But yeah, it's certainly better than being able to be evicted immediately if you can't come up with the full amount. So that's kind of it for the repayment plan. I did include a link in the useful links document to the RTB form, basically, for a repayment plan. So it's RTB 14, and it's a fillable form on the website, and it will include all of the details that have to be included in the legislation, and it sets out the table and everything, and the beginning date and the end date, and then the landlord signs that, and both parties would want to keep a copy for their records. I guess one thing we haven't talked about too much is that a tenant can give the landlord this repayment plan as well to cancel a previous agreement, or if the landlord is saying, well, no, I want you to just pay it all back right away, the tenant can fill out one of these repayment plan forms and serve that on the landlord, and that would cancel any previous agreement that the tenant doesn't like anymore, and prevent the landlord from trying to say, oh, well, you have to pay it all at once, or you have to pay it within a couple of months, or else I'm going to evict you.
Mm-hmm. There's just, I think everybody's really working to understand this bit here, so I'm going to just take a bit more time. So rent for September and October and beyond is not considered under the definition of affected rent, correct?
That's right. Yeah, they've delimited that period specifically in the legislation to March 18th to August 17th. And so if some unfortunate person had rent due on the 18th, it would have had to have been paid in full and on time on that date, or the tenant could be subject to non-payment eviction, just like before. And
then there's still sort of I don't think it's you, Michelle. I think it's just the legislation, and
it's confusing. I mean, yeah. I've spent a lot of time reading it and going over it, so yeah, I have a handle on it. But yes, it's complicated and confusing.
So when can the landlord issue eviction for non-payment of installments?
It will be as if that installment was part of the rent.
Okay.
So right now, if you're $10 short on your rent, sorry, not right now, but going forward, on September 1st, if you owe $800 rent, you have to pay that $800. And if you're even a little bit short, the landlord can issue you a 10-day notice for non-payment. You would have 5 days to come up with whatever the outstanding rent was in order to cancel that notice. And if not, then you could be evicted in 10 days. So that additional payment, the repayment installment, will basically count as rent. So if you owe $800 plus a $200 installment, but you only have $950, then that missing $50 could ground a 10-day notice for non-payment.
Okay, well, that definitely clarifies things. And there's still some questions around this repayment plan, but it really, landlords cannot in any circumstances demand the full amount earlier, and or they can't break up the payments in a way that is unequal or unfair to the tenant.
They have to be equal payments by legislation. That a landlord and tenant are allowed to amend that and make smaller payments earlier.
Right.
But otherwise, no, they can't be weighted in any weird way so that the landlord can't say, well, I want $500 a month for the first 2 months, and then you can pay off the balance in smaller installments. They have to be either equal or smaller at first.
Mm-hmm.
I don't know how they came up with that but fair enough.
Yeah, and then the other question is around what if a landlord waits until June 2021 to demand a repayment plan? Would that mean that would still be in
because
effect?
that's affected rent. Like they can't. Oh, actually, I guess that's an interesting question. Like if they said, you know, on June 10th, they said, okay, well, I want a repayment plan.
Yes.
And
yeah.
all the rent is due next month. I think at that point, I would advise a tenant to contact us or another advocate and file with the branch. That sounds like it might be considered unconscionable,
Right.
or unfair, but I don't know that I'd have to look at the legislation again and see. Yeah, I guess the short answer is I don't really have an answer to that. I can look into that and get back to you.
Good. And often what we do in these webinars, if you're joining us for the first time, is we will connect you with Michelle directly if your question didn't get answered during this period of time. Track is very open. That's what they do, is they talk to people about their particular situations and try to help people on an individual basis. So shall we carry on here?
Yeah, so were there more questions about the repayment, or?
Let me just see here. There's a lot of them. I'm just trying to summarize. Is there any way in which a landlord would lose the right to request a repayment?
I don't believe so. Although that question about waiting until it's almost the end of the repayment period is an interesting one. And like I say, I'm not sure. There may be an answer to that in the legislation, and I just haven't thought of it, so I don't know what it is offhand. But the way the legislation is framed, the intent behind it seems to be that if a landlord has the intention of collecting on this unpaid rent, that they must do so by issuing a compliant repayment plan, and that they can't do it any other way. That's that's the intent behind the legislation. Whether there might be some loophole in there that would enable a landlord to do something weird, I'm not sure. I don't think they've indicated that there must be at least X number of installments. But yeah, I would have to go back and look at that. I can come back with an answer for that.
Okay, great.
For you, Sarah, or to whoever asked the question. I mean, it's a question of general interest. So
Yes,
I'll
absolutely.
figure that out and get back to you.
Okay.
Yeah, so with respect to actually removing a tenant from a property, so for a landlord to obtain vacant possession of a unit, a landlord still has to get first an order of possession through the residential tenancy branch. Then with that order of possession in hand, and after any applicable review periods have passed, they can file with the BC Supreme Court with, it costs money and there's a bunch of forms to fill out, including an affidavit of service. So they have to swear that they properly served this order of possession on the tenant. They can then obtain a writ of possession from the court, and a writ of possession is legal authorization to then obtain the services of a court-appointed bailiff. A bailiff can go and attend, sometimes with the police if that's deemed necessary, to physically remove the tenant and their belongings from the unit. So landlords, as of June 25th, I guess, can enforce orders of possession through the Supreme Court. So when this emergency period first started at the end of March, landlords who had existing orders of possession, so say they've got one, in the middle of March, but they hadn't enforced it yet, were not going to be able to obtain a writ in Supreme Court, unless, as we discussed, there was one of these urgent evictions, cause evictions. So beginning at the end of June, landlords could enforce orders of possession that they obtained prior to the emergency period, and writs of possession started to be able to be enforced as well, because the bailiffs too during this emergency period were not working basically, unless there was an approved type of eviction. But that all ended at the end of June. And so again, beginning after August 18th, all of this will also apply to new unpaid or late payments of rent or installment plan payments. So landlords do sometimes, this is just general information that I'm going to go over just because it's always applicable. Landlords do sometimes try to get a tenant out without recourse to a writ of possession or a bailiff. If they lock a tenant out or threaten to lock a tenant out, the residential tenancy branch now has an enforcement and compliance unit. It's a very small unit. It's based out of Victoria, but they can intervene in those types of lockouts. So the process is generally when a lockout starts, a tenant can file with the RTB. They can make an application for an order of possession, for an order that the landlord obey the Tenancy Act and the agreement. But they can also make an compliance and enforcement complaint. That form is available online and it can be submitted by email. And the tenant can set out, this is an urgent matter, I've been locked out, I need compliance and enforcement immediately. I've had some success with those types of interventions. So I've had, even though there's only 4, I think, investigating officers, compliance and enforcement officers, I've had them get back to me within 24 hours, and once, I think on the same day, to get, further information, contact information from the landlord. And unlike the residential tenancy branch information officers, they will contact a landlord, and they will talk to them and explain that if a landlord continues with these non-compliant acts, that they can be fined and administrative penalties can be imposed. They can also intervene in other types of serious problems if there's a health and safety issue, if the landlord's doing something or refusing to do something that needs to be done, they can intervene. As I said, the form is available on the RTB website, and the form itself includes the email address where the form can be sent. And they will accept, you can email evidence, including audio or video files at the same time. I had one client who was, who could hear on her video surveillance that her landlord was changing her lock, and then after changing it, the landlord came into her unit, obviously without permission or notice, and we were able to send those video clips to compliance and enforcement, and they were able to intervene and get the RCMP to attend as well, which that's something that's very difficult for a tenant to do. Police and RCMP are usually pretty reluctant to intervene in anything they see as a civil issue, or especially if it's before the residential tenancy branch. They're usually quite hands-off, and they will allow these illegal lockouts or evictions to go ahead. Initially, what the police were going to do in that situation was just get the landlord to let the tenant in to get her, her medication and her ID. My understanding is it wasn't until compliance and enforcement intervened that the police actually told the landlord that what he was trying to do was illegal and that it could be a criminal matter if he proceeded.
Just a quick question about the enforcement unit and
Yep.
their scope. Do they deal with things like disputes around bugs, rodents, or mold that's not dealt with, or is that a separate thing?
What they do is they will assist after a tenant already has an order or something like that. So if there's a pest problem, the process is that the tenant has to proceed through the branch to get an emergency repair order or an order that the landlord do pest control. Those hearings can happen pretty quickly. You can get an expedited hearing in 3 or 4 weeks. But the compliance and enforcement unit is not kind of a first line. They will get involved after there's been a dispute resolution and an order has been issued and not complied with, usually. For things like lockouts, they will sometimes intervene kind of ahead of time or in a timely way.
Okay.
So one of the issues that comes up with respect to COVID is just access to justice issues. So as I said, the practice directive on extending timelines was quite helpful because it gave arbitrators more discretion to extend timelines and adjourn hearings. That document was rescinded, as I said, on June 24th. Arbitrators are, the practice directive has said that arbitrators can continue to apply those principles to COVID-related circumstances. Well, first of all, to ones that arose before June 24th, but also going forward on a case-by-case basis. So essentially, if a tenant, for instance, has a specific health concern, or if they are in quarantine and they can provide evidence or proof of that, then an arbitrator will consider, extending timelines or allowing for an adjournment. Previously, it wasn't necessary to have sort of proof or evidence that you were particularly affected by COVID. It was just that, you know, if you said, well, I because of the pandemic, I couldn't get to the post office, or I couldn't get to Kinko's to, you know, copy or print out all of my evidence and mail it. And in that case, an arbitrator would give them more time. Now, I think, anyway, it hasn't really come up, but I think now you would be expected to show that you were immunocompromised, or that you had been directed to self-isolate, in order to be able to sort of use that as an excuse for needing to extend a timeline. So yeah, as it says at the bottom there, for if you have clients who are facing hearings or who are experiencing these issues with access to justice, do let us know. And we do have a housing law clinic that's relatively new, just started in January, where we can now do judicial reviews at Supreme Court. So these would be reviews of unfair decisions for one reason or another. Often those would be evictions, but they could be things like monetary orders. So if a tenant is facing a really significant bill from a landlord for damage or something that the landlord says was caused by the tenant, and the RTB decision goes against the tenant, that might be something that the housing law clinic would help with if the decision was in some way unfair or procedurally unfair. So some other kind of COVID related issues during the initial emergency order, tenants were allowed to refuse access to landlords. So even if a landlord gave proper 24 hours notice, they still required a tenant's explicit consent to come into the unit. That has been lifted as of the end of June. And so now landlords and their agents can enter just as it was before. All they have to do is give 24 hours notice. It has to be for a reasonable reason and within a reasonable time period, but a tenant can no longer refuse on the grounds, even if they are self-isolating or in quarantine. The branch does have a kind of a vague directive that landlords and tenants are expected to practice safe physical distancing or wear masks, but there's nothing really binding about that expectation. Landlords, however, can still restrict access and guest access to shared spaces, including elevators, laundry rooms, places like gyms and locker rooms and pools. And tenants are not entitled to any kind of rent reduction for losing access to those services or having those services restricted.
So, for example, laundry is a big deal. Landlord could just shut down the laundry room and cite COVID, and that would be okay?
Well,
or can they just restrict the use of the room?
They might have a hard time closing the room altogether and refusing to let anyone use it. The RTB they've even produced kind of a little poster about shared laundry rooms that basically sets out the kinds of cleaning suggestions or restrictions that they recommend. In a case where a landlord had closed access to something altogether, I think a tenant probably could have recourse to the branch at that point, and get an order saying, in fact, some access has to be allowed. Mm-hmm. I think that would be a possibility. They have to be reasonable restrictions, and reasonable, of course, is not defined because it would vary. But I think where the branch has really explicitly set out, like, here's ways that you can make the common laundry room safe, that it might be considered unreasonable if a landlord just said, no, nobody can use it.
Right.
Yeah, so the other issue that I touched on briefly earlier was that the rent freeze is now over. This was actually a rent increase freeze. So not only are tenants now responsible for paying rent and can be evicted for non-payment of rent, the rent freeze has been lifted. So rent increase notices that were served on or before March 30th to take effect on or after April 1st, those notices they're still valid. They don't have to be reissued or issued with new dates. They just won't take effect until December 1st. So if a tenant got a rent increase notice, in February of before all this happened, that was supposed to take effect June 1st, the landlord doesn't have to reissue that notice. It's just now that rent increase is going to take effect December 1st. And landlords are now free to issue new rent increase notices. I mean, they could issue them before anyway. They just weren't going to take effect. They can't issue, that doesn't change any of the other timelines. They have to give three full months for a rent increase. So if a landlord issues a rent increase notice now, they still have to give September, October, and November for the rent increase. That's why the date is December 1st for new rent increases. Did that make sense? Are there questions about that?
Yeah, no, I think that part's pretty straightforward.
Okay. This seems to cause a lot of confusion with our tenants that contact us asking for help. The bottom line seems to be old notices that weren't effective, like they couldn't come into effect, are still going to be considered valid. They don't have to be reissued. So just going over the financial assistance, the important thing about this is just that the BC, the temporary rental supplement, the TRS, is over. It ends August 31st. So nobody is going to be getting their $300 or their $500, depending on what they were eligible for, after this month. Yeah, the BC emergency benefit, that was a one-time payment anyway, so anyone who was eligible for that probably received it already. The CERB, I haven't heard anything more about that, if that's going to be extended or what, if there's any plan for that. I would, the SAFER and the RAP plan, I don't believe they ever had any sort of additional or bonus money. What they had done for the SAFER and the RAP was that people who had, lost income could apply to get an adjustment to their benefits, sooner than the usual, annual application or whatever. Anytime your financial circumstances change with SAFER and RAP, I think you are eligible to apply for an adjustment to the benefit. So I don't think anything has changed with that. And again, just reiterating, the Premier previously said that no tenant would be evicted due to COVID-19. I think it's quite clear that with these, with ending the special provisions this soon, before the pandemic is over and before people are back to work, I think it's pretty clear that we are going to see evictions precisely because of COVID. I would encourage people to reach out to their MLAs and let them know about situations that they see or hear about from the tenants or the people that they work with, just to try and keep some pressure on the government to consider further measures or reinstating these measures. I didn't look at the numbers from yesterday, but I know we're seeing climbing cases, really big numbers for the last week, and with school and businesses, you know, ramping back up. Well, who knows? That's kind of off the topic, sorry. But I encourage people to reach out to their MLAs if they're seeing injustices with respect to the Tenancy Act and these provisions.
So just before we jump forward, there's a good question here around rent increases. If someone got a notice before April and they haven't heard anything since, would it be safe for them to assume that that rent increase will begin on December 1st, even if they haven't been directly told that?
Yeah, I think that would be safe to assume.
So it's not
Sorry,
like
I just have I'm just going to mute myself for a second because I've got a cough here.
It's not like a freeze. It's more, the concept is more that it's a pause. And even with evictions, there were some that were still valid, but they couldn't actually be enforced because bailiffs and court orders were not being issued, writs of possession. However, if an eviction had grounds for cause, including destruction to property, etc., it still is a valid reason for eviction. From what I understand, it's like we just press the pause button, but there are things in place that now are going to
Resume.
Yeah.
Yes, I think that's the right way to look at it with the rent increase notices. I think unless a landlord has specifically rescinded that rent increase, then if it was properly served to them, I think they can assume that it will take effect on December 1st. And yeah, with respect to sort of previous evictions or pre-existing orders of possession, I know one tenant that someone called in about them, they just received a notice of intent to enforce an order of possession. So their landlord had obtained an order of possession some, you know, a couple of months ago. And that landlord is now signaling their intention to go ahead and obtain a writ based on that OP. That's not a requirement, by the way. So it was, you know, it was good of that landlord to issue that letter warning the tenant that they intended to proceed with a writ, because otherwise a tenant has no notice. There's no notification requirements for a landlord to let a tenant know, okay, today's the day, like we're going down to court and we're planning on obtaining a writ. So yeah, throughout this period, like through March and April and June, we were still, and other advocates were still having eviction hearings for evictions, you know, the notices that were issued previously. Those orders of possession were still being issued if the landlord was successful, just with the caveat that the order of possession wouldn't be enforceable until the moratorium was lifted and until the Supreme Court was issuing writs again. So, yeah, as I mentioned, the document service changes have been rescinded. Email service is again not an approved method of service. They're saying that substituted service applications may be granted based on COVID-related issues. In order to get an order for substituted service by email before, you had to sort of prove that the landlord either wasn't picking up their mail or that they had changed their address and you had no way of reaching them by mail. Now it seems as though they're saying they may approve email service just if you can show maybe that you're immunocompromised and it's not safe for you to be out at the post office or going door to door or handing something to your landlord in person. And in-person service is now allowed again. that's been since the end of June. That was temporarily lifted in favor of email service.
That's kind of
there we go.
Seems like we're going backwards, you know. Email is a way for an access to justice for some people, and
yes, very frustrating that they lifted it. I don't understand the rationale behind lifting it. They did say, I think I mentioned, they did say at the time that they hope to have new email service provisions in place for September, but I haven't heard anything more about that. That's been very, very helpful for people, and for us as advocates, trying to help clients remotely. If they can send stuff to us and we can email it for them, that saves a tremendous amount of time and money and risk.
mm-hmm.
I don't see that it's any benefit not to have email service.
Yeah, I'm in agreement with that. So I just want to say thank you for all the specific questions that have been asked during Michelle's presentation. We're going to dig into some of them more now. First, I'm going to go back to, you mentioned special terms for repayment, special circumstances. And so there's a question here around, for example, if a landlord is compassionate and makes some special terms for repayment that do not align with the legislation, but then goes back on those special terms that were agreed upon, would those still protect the client, or would the legislation take precedence? So specifically in relation to a repayment plan.
So there is some flexibility that's allowed around the repayment plan. So there are ways in which it's allowed to be amended that would be favorable to a tenant. So a landlord they can agree to a longer repayment period. They can agree to, it seems to me that they could agree to a kinder, gentler repayment agreement, and that would still fit in with the legislation. The things that can't be changed, that are rigid, are things like that the payments have to be equal or helpful to a tenant, in the sense that the payments are longer, or they're smaller in the beginning. A landlord is allowed to give more time for repayment. I don't think there's any, maybe there is. I can't think of any way offhand that an amended agreement that would be favorable to the tenant would not be allowed under the legislation.
Yeah, so there's no kind of magical deus ex machina special circumstances that would supersede legislation here.
No, I think the legislation allows for terms that are more favorable to tenant, and the only thing they would not allow would be terms that were less favorable. So the agreement would be whatever the agreement was. The tenant would want it in writing. Like, the part of the concern in the question seemed to be, well, what if the landlord reneges on the agreement or goes back on the agreement? They shouldn't be able to. If it was written down, the tenant should have recourse to the branch. And as long as the amendments were those ones that were more favorable to the tenant, so if they were smaller installments over a longer period of time, I would think that would be enforceable.
Okay.
That the landlord wouldn't then be allowed to say, well, no, I want to go back to what the template repayment plan terms were. I don't see that would be allowed. Because
they had made a written agreement with the tenant, which is valid.
Yeah.
Yeah.
Yeah. Yeah. So the repayment plan, it's like there's it's a floor and not a ceiling. Like, they're pretty minimal terms that the landlord has to provide, and anything that they provide that's better than that is probably allowable and would also be enforceable.
Right.
It's not like the only terms that are enforceable are those kind of ceiling, like basement level terms.
Right. It kind of ties into a larger question, which I'm picking up on as a theme here, and that is something that we talk about in other webinars with you, Michelle, and with TRAC, is What is the recourse for tenants to access justice when it comes to landlords who don't fulfill their agreements? We could talk about it specifically in the case of a repayment plan, but sort of if you can offer a straightforward, like how do you deal with landlords who don't keep their word and aren't following the legislation?
I mean, generally speaking, you have recourse to the branch. Tenants or advocates working on their behalf can help them to file for an application, for an order that the landlord follow the act, or an order that the landlord follow the agreement. So in a case of a repayment plan, if a landlord refuses to provide a repayment plan, then that's really more of a question for the landlord, because what are they going to do? They can't make someone pay them back. They can't, they don't have any recourse to get that money apart from a repayment plan. So if a landlord was doing something like intimidating or harassing a tenant because they were refusing to pay, the full amount of a thing, then again, a tenant could apply to the branch for an order, for a quiet enjoyment complaint, or an order that the landlord stop harassing them about it. A landlord doesn't have sort of legal recourse to make something happen that's not allowed under the legislation. So in this case, to make a tenant pay them back a bulk repayment, or in any other terms other than an allowable repayment agreement. And also in that case, a tenant can provide the landlord with the repayment agreement and then could file with the branch to enforce that, or in order that a landlord comply with the terms of the repayment agreement. Generally speaking, that's the recourse, is that you can file with the branch for all kinds of orders, compliance orders, orders to repair, orders to fix problem, orders to do or not do certain things. There's a greater problem, like a huge problem, which is just that sometimes landlords behave very badly, and they're going to continue behaving very badly no matter what kind of paper order is in place. And there's no real solution for that. I mean, the compliance and enforcement unit is a helpful development, and I wish that they were expanded and less busy and could do more, because I think it would be very helpful to be able to have more access to official people who would contact a landlord and say, hey, you have this order, you have to do this, and if you don't do this, we will start applying administrative penalties of up to $500 a day. That would be helpful. I'm not sure that answered the question, did it?
Well, I mean, I think it's a case of this understanding of the new legislation. So there's legislation in terms around a repayment plan, but some landlords could be more compassionate or give longer terms, et cetera, et cetera.
Yeah, and that would be allowed.
And that's
if
all
they've
allowed.
already, if they've made a prior agreement, the prior agreement doesn't have to comply with these terms.
Okay.
It would still be binding. If the prior agreement is not as favorable as this legislated agreement would be, then a tenant can cancel it by giving the landlord a new repayment plan.
Right. And it
But
kind of
even,
sorry, go ahead.
Sorry, go ahead. No, go ahead.
It kind of comes back to this concept, this sort of foundational concept when we talk about the RTA and the RTB, and that is when you have an agreement in writing between a landlord and a tenant, that agreement, as long as it's within the confines of the act, it is valid. So
Yes.
the best thing to do is always make agreements with your landlord in writing, and then that's proof. If they are reneging on it or not holding it up or changing the terms, you have a very solid piece of evidence to take to the RTB for dispute resolution.
That's right. Yeah. It's not always possible to get landlords to put agreements in writing. But what there are other things that you can do if you have a conversation with your landlord and they agree to something. You can always just write that down and text or email it to them. And that's at least something. That's some evidence of the agreement that you have. So if your landlord says, okay, well, we can do this, and you can give me, $100 a month for 6 months, and then we'll call it even. You can write them a text or an email that says, so just to confirm what we talked about earlier, this is what we're going to do. And then that's at least some, if they won't sign a formal written agreement, if you can at least show some correspondence acknowledging that those are the terms or what the terms are, that can be helpful.
Good.
But yeah, with something like a repayment agreement, if there was one that was arranged previously, I would expect that there would be at least some documentary evidence of that, like that someone would have written down, in an email even, or a text or whatever, like this is what we're going to do to deal with the arrears.
And I mean, I now live in a co-op, which is, I feel very lucky, but I have been a renter in East Van all my life. And I know that, even with somebody who doesn't have as many barriers as others, it was difficult to talk to my landlord about getting things in writing because they lived above us, so there's that personal relational aspect. So I do understand that it is actually, it's a big ask to ask somebody who already has difficulty or is afraid of, whatever, or like there might be other stuff going on for them, to actually get a written agreement from your landlord can be very difficult. Yeah,
it definitely can be, for sure. And very often you have landlords who have language barriers or who themselves do not understand or are aware of their obligations under the Act, or who are, desperately trying to hide the fact that they have rental income and are very leery of any kind of official or on paper. We've got lots of landlords who won't give a rent receipt. We had this come up a lot with the temporary rental supplement. Many landlords were just afraid to talk to anybody about money that they were getting because they were worried that it would impact their taxes, or they had, that it would impact maybe other benefits they were getting. But yeah, definitely there are can be lots of barriers to getting anything in writing, which is why sometimes the option of following up with a text or an email can be helpful, because sometimes people are willing to, reply to an email and say, yeah, that's what we talked about, or yes, and you can give me the first payment on the 15th or whatever.
Right. Good. Well, we've got about 3 minutes left, so I'm going to ask you a couple more questions. Just a reminder to everybody, if you can stick around to fill out that survey. So this is actually a really good example of what we've been talking about, and it's just a scenario, and that is, if a tenant was late on rent regularly over the past 5 months during this pandemic, come September 1st, can a 1 month notice due to repeated late payment of rent be issued? Or is that period exempt?
That period is exempt. Affected rent, so anything that was late between, what did I say again, March 18th and August 17th, that can't count towards repeated late payment of rent.
Okay.
The example I gave earlier was like if they were late in January and February, and then again in September, that would count. Those two late payments before March 18th could count.
Yeah. And then there's a question here around eviction. So if there was something that happened previous to June 24th, like damage to property or there was a cause to
Cause of
evict,
some kind, yeah.
can you then get an eviction notice that is retroactive for that period now?
Yes, there's no reason why not.
Okay, so a
There's
landlord.
no kind of exemption period for like bad acts or cause apart from like, so if somebody was, you know, making a mess or breaking stuff or bugging their neighbors, that could still form grounds for eviction. It may be a little bit harder to establish the cause if it was like a thing that happened 3 months ago and hasn't been repeated since. But if it was egregious enough as a one-time thing to warrant eviction in June, then I would think that yes, it could still ground an eviction in August.
Okay. Well, I just want to say thank you, Michelle. You've pulled together, I mean, the announcement happened just a few days ago and then
Yeah,
yesterday. So
yeah.
you've really pulled together a lot of really relevant content for us. And I'm putting this slide up on the screen because in my experience with TRAC, I mean, this is what they do. You can contact them, they hear your specific case, and they give you specific advice and knowledge on that. So there's lots of ways you can get in touch with them here. I am going to connect as well a transcript to Michelle of all the questions that have been asked during this webinar so that if there's anything that she wants to respond to or think more about, we will have those answers available to you. And just very briefly, hsa-bc, we don't have any more webinars scheduled unless something comes up like this one did, but we will be having our first annual conference in September. It'll be online, so you can check out the website there and register for that. It's going to be, the topic is going to be health and homelessness, and there's some really incredible keynote speakers as well as relevant workshops and sessions for you. And you can also take a look at our website, all of our upcoming trainings, all of our sector resources, webinar recordings, podcast episodes, handouts, information, etc., is all available in our sector resources and on our website. And you can also get in touch with us at any time. Let us know what you're needing right now and what are the challenges facing you in your organization. Because like I said at the very beginning, we are tailoring all of our training to the needs that are in our sector right now. And because we can do it via webinar, we can be very adept and flexible at pulling things together on short notice, like we asked Michelle to do. So thank you so much, Michelle, for being here today and just sharing what you know. We really appreciate it.
Oh, you're welcome, and thanks for inviting us. And I'll figure out an answer to that one question about what if a landlord just waits and waits to issue a repayment plan.
Good.
And I can send that out to you. And yeah, whatever other questions that you're sending in. And I do encourage people, like I said, to contact us directly if you have specific questions or issues that come up.
Good. And I just very quickly, are you aware of anything that TRAC is coordinating in terms of broader public advocacy around these issues that have come up today?
Well, we're involved. We're involved in stakeholder meetings with the RTB, where we give our input about what we think should be happening and what the effect of proposed changes would be. We also work with other advocacy and legal organizations to lobby, basically, to come up with sort of position papers or press releases or letters to government about specific steps or measures that we think should be taken. And we do, through social media, we try to do what we can to get information out about different changes to the RTA and what what tenants can and should do in terms of, you know, their rights, and like I said, contacting their MLAs to bring these issues to the fore. The government hears a lot. I assume they must hear a tremendous amount from developers and from landlords and from those kinds of interests. And I think they can be very influential, and it's important for the voice of individual tenants and individual advocates to be heard, as well as kind of groups like ours that try to do systemic advocacy. And that's my pitch for for writing or calling your MLM.
Good. All right, everyone. Hopefully you get a chance to take a break today at some point. The work you do is very important. It's very necessary, and it has been very complex in the last few months. You know, it always is complex, but we at hsa-bc really appreciate the work you do on the front lines, and we're here to support you however we can. So take care, everyone. Take a break if you can, and hopefully we'll see you again at our conference and at some other webinars.
Okay, thanks again.